Hello, my fellow left-wing commie, pinko, libertarian, anarchistic bastards. So, I'd like to first of all welcome our new Thursday. Then, I would like to tell you a harrowing tale of the Supreme Court, strip searches, and the war on drugs. And, of course, this will end in me being very, very angry. Enjoy! Beginning this Wednesday, April 22nd, the Supreme Court heard oral arguments in the case Safford Unified School District v. Reading. This was a case that is particularly, well, scary, I would say. It's the American Civil Liberties Union representing a student who was strip searched because she was accused with no evidence except the testimony of another student who had been caught with ibuprofen of having ibuprofen. Now, in the first place, having ibuprofen shouldn't be a crime. It's not that big of a deal. Yes, you can use it to get high. You can use lots of things to get high. That does not warrant the school engaging in a strip search, particularly if they are bereft of evidence. And the court below this that heard this case claimed that it was just completely obvious that this was a violation of the Constitution. I mean, due process and right to be protected against unreasonable search and seizure, it's pretty obvious that this is unconstitutional, even though children often have fewer rights. So here's the details of what happened. So on October 8th, 2003, the school's vice principal, Carrie Wilson, pulled Savannah Redding, an 8th grade honor roll student with no prior disciplinary record at Safford Middle School, from class because Wilson had discovered some ibuprofen, 400 milligram pills equal to 2 over-the-counter ibuprofen pills, in possession of a classmate of Redding. So when she was questioned, then the classmate claimed that Redding gave the pills, and of course she was under threat of punishment, so of course she was going to deflect the blame. This is a child. And so they brought in Redding, and they had her search her stuff. She obviously complied, even though she didn't know what was happening. Then, after they found nothing, hence that would generally inform you that there's nothing happening, but not apparently to these guys. They took her to the nurse's office and had her stripped to her underwear. She then had to pull her bra out to the side, exposing her breasts, and she had to pull her underwear out to the crotch, exposing the pelvic area. And, of course, no ibuprofen pills were found. Oh, so you can see how this might cause a problem. And Redding said that the strip search was the most humiliating experience she had ever had. Well, I would think so. This effectively, from the perspective of the victim, would amount to molestation. This is madness. Madness, I tells ya. And so that happened. Then, fast forward to Wednesday, the Supreme Court started hearing oral arguments. I don't think any of them doubted that this was unconstitutional, really, but let's hear what Justice Souter had to say. He said, "My thought process is that I would rather have the kid embarrassed by a strip search, if we can't find anything short of that, than have some other kids dead because the stuff is distributed at lunchtime and things go awry." What this translates to me is, of course we need to violate children's rights. Think of the children! Fuck that shit. So, that argument also reminds me a lot of my least favorite Supreme Court case, Schenck v. United States, where they're saying that there's some clear and present danger that makes basic constitutional rights something that we can't afford. Now, keep in mind, there was no evidence for any potential harm, and there's really not significant reason for such extreme tactics to be applied against the dangerous threat to our children that ibuprofen poses. I mean, as Radley Balco said, at this point, the drug war can't really be parodied, can it? This is some of the most extreme, illiberal nonsense I've ever heard. If the ACLU doesn't win this Supreme Court case, I don't know how we could possibly have any respect left for the Supreme Court. This is an obvious, open and shut case of basic due process and search and seizure rights being violated. It's something where also it could be quite easily argued that performing the search amounted to some sort of molestation, and charges should be pressed against the people rather than mere firings and such. But that's not my place. Clearly, the system is screwed, and we need to do something about it. Hopefully, the Supreme Court will make the right decision.